Thank you so much, Senior Advocate Femi Falana, for joining us tonight. I mean, we followed the El Zazaki case, but it has a larger implication under the law and, of course, in the case of civil unrest and human rights in Nigeria. Let me get your take on this, what has happened over the last few years on Sheikh El Zazaki.
Well, yesterday, the Kaduna State High Court discharged and acquitted them on the basis of our no-case submission. Following the service of the warrant of release on the prison authorities, or the authorities of the Kaduna Correctional Center, they were released. I mean, both Sheikh Ibrahim Ezaki and his wife, Madam Zenat, were released, and they are currently enjoying their freedom. They have been released, contrary to expectations of many people, because many people have been calling me since yesterday, oh, are you sure they are going to be released? Will this government obey the order of the court? But I can say without any fear of contradiction that, they have been released. The authorities of the Correctional Service of Nigeria complied very promptly with the court order. And so, I think it's a good development, having regards to the fact that since December 14, 2015, the couple had been detained initially by the State Security Service, and we were in court, and on December 2nd, 2016, the Federal High Court ordered their release and awarded damages of about 50 million naira to both of them. The federal government treated the orders of the court with contempt, absolute contempt. Of course, the Shiites mounted pressure on the government by protesting on the streets of Abuja. In the process, many of them were killed, and at the end of the day, the government felt the protests were becoming a source of embarrassment, and that was why the Kaduna State government decided to charge the couple with some, an 8-count, took them to court on an 8-count charge. But as I'm saying, by yesterday, the court ruled that there was no basis for them to have been put on trial. Hence, the court upheld our no-case submission. So as I said, they have been freed. So, I mean, it then brings me to a very critical matter. Human rights is very fundamental in our laws. And for our society to thrive also, people's voices need to be heard and their rights need to be protected. Well, how do we tame extremism? Perhaps, what is the place of the law? What does the law say about the extreme tendencies in people expressing their views or their rights? Well, by virtue of the provisions of Chapter 4 of the 1999 Constitution and the African Charter on Human and People's Rights, Nigerians, and indeed all persons living in our country, are entitled to fundamental human rights. But we are in a very perilous time whereby we are being told by top government officials, particularly the Attorney General and Minister of Justice, Mr. Abubakar Malami, SAN, we are being told that human rights are not important and that national security take precedence over human rights and the rule of law. For me, with profound respect, human rights cannot give way to national security, because you must look at the totality of national security. That's not about the security of the people in power, it's about the security of the country. Hence, Section 14, subsection 2, subsection B of the Constitution provides that the security and welfare of the Nigerian people shall be the source of, the primary purpose of government. The Constitution does not say the security of the government, but the security of the Nigerian people. Of course, there are officials of the government, like the president and the governors, who are also part of the security of the nation. You know, they represent, you know, part of the security of the nation. Hence, any attempt to remove them from power or to attack any of them are either classified as treason or treasonable felony, because they also represent the state. And that also means that they must represent the interests of the entire people of the country and ensure, and they take oaths of office on their inauguration to respect the Constitution, to respect Chapter 4 of the Constitution and Chapter 2 of the Constitution in particular. And so, if they or any official of the government or any agency of the government violates the rights of Nigerians, you have to go to court. And once the court has given a judgment or given an order, no authority has the power in Nigeria to decide, oh, we are not going to obey this order because we consider in our own office that, this judgment of a court is not in consonant with what we feel, what we think is national security. And if you maintain that position, you are violating Section 287 of the Constitution, which provides that the judgments of our court, the decisions of properly constituted court, shall be binding on all authorities and persons in Nigeria. In the case of the Ezakizakis, between December 2016 and May 2018, when they were now arraigned before a high court in Kaduna State, the government could not defend the reckless infringement of their rights to liberty. And for me, this is a warning to all of us that we need to respect the rights of people, because sometimes you may also be the victim. You may be a victim of human rights violation. It has happened to people in power who were detaining people, you know, frivolously. I was detained in 1985. But by the time President or General Muhammadu Buhari, as he then was arrested and detained for 3 years, his deputy, the late General Tunde Ide-Agbon, detained for 3 years by the Ibrahim Babangida junta. We had to rally around ourselves, those of us in the human rights community, notwithstanding that we have been brutalized under that regime, to insist that we have to demand for the release of these two gentlemen. And our position then was that if we allow the Babangida junta to detain a former head of state and his deputy, and we simply keep silent, what will happen to the rest of us? And so we demanded for their release, and they were so released. So each of us will need human rights. We need to approach the court to protect our human rights.
That perhaps also because what happened on the sideline of the Global Education Summit that President Buhari is attending in the UK brings me to the issue of extremism that I was asking earlier. At that meeting, there were conversations between President Muhammadu Buhari and the Prime Minister of the United Kingdom, Boris Johnson, and both leaders agreed that judicial process should run its course. And it was part of the review and the process and the conversation that they had that the war against different forms of terrorism in Nigeria should pass judicial process and be allowed to run its course. And President Buhari also asked Prime Minister Boris Johnson that they need help of Britain in fighting terrorism and also in achieving food security in Nigeria. And simply, the Prime Minister told President Buhari that, quote, we are available to help. So I'd like to ask Mr. Falana, we've seen different kinds of agitations in the country, from the Sunday Igboho to Nnamdi Kanu to how do we tame these agitations?
Again, the question of human rights is involved here. Personally, I am strenuously opposed to the campaign for the balkanization of Nigeria along ethnic lines, because I believe that the masses of our people are oppressed by the ruling class and imperialism. And to that extent, I have a fundamental disagreement, a fundamental ideological disagreement with those who are calling for a breakup of the country along ethnic lines. But the law has imposed a duty on the government and the rest of us to respect the rights of such people. In fact, Article 20 of the African Charter on Human and People's Rights Act provides, guarantees the right to self-determination. So if a group of people decides to fight for a breakup of the country, the duty of the government is to try as much as possible to convince them to repose confidence in the corporate existence of Nigeria. But you cannot criminalize their demand, because it is not a criminal offense in Nigeria to demand, to make separatist demand. Government officials at the level of the presidency and the level of the governors are making separatist demands. When recently President Muhammadu Buhari ordered the Attorney General to go around looking for grazing routes, and the entire country never had grazing routes. But that, as far as the law is concerned, as far as I'm concerned, was a separatist demand.
Just a moment. Just 1 minute, Mr. Falana. I like us to fix some of the technical issues that we're having. We'll take a break, and when we come back, I'll allow you to continue on that thought. Stay with us, everyone. We'll be right back. Thank you so much, everyone, for staying with us. Mr. Femi Falana is still with us, Senior Advocate of Nigeria. Apologies, Mr. Falana, for breaking into that your thought. I just wanted us to be able to see you so that we can be able to connect to what you're saying. And thank goodness still we have been able to fix that issue. So please continue on that line of thought.
Yeah, I'm saying that when governors and other political leaders demand that the presidency of the country be rotated along regional lines, or that the presidency should go to the north or the south, that is a separatist demand. And so when young people are also influenced by the ideas of the ruling class to make separatist demand, we just have no business criminalizing their action. But be that as it may, with respect to Mr. Nnamdi Kanu, I did say to the government, if you want to bring him back to the country, please file a request and ask the British government to file extradition proceedings to bring him back. At the time he was found in Kenya, one would have expected our government to request the Kenyan government to initiate extradition proceedings, because among the Commonwealth member states, there is a treaty between Nigeria and Kenya. We have a treaty. And so, in the case of, but what we were told was that he was abducted and brought to Nigeria, contrary to international law, and contrary to the domestic law of Kenya. In the case of Sunday Igboho, again, despite my disagreement with him, I came out to say, you cannot just throw him into a waiting plane, as we were told was attempted. You have to go to court. You have to make a request under international law, under the ECOWAS Convention on Extradition. The government of Nigeria is requested to submit an extradition request to the government of Benin Republic. And so when our plenipotentiary, General Yusuf Buratai, retired, who at that time had not even submitted his letters of credence, asked for that Igboho be handed over to him, he was told, sorry, we operate the rule of law here. And that is why that matter is still in court. Now, the point I was making, and I've made the point today, with respect to the request of the American court, an American court, for the arrest of Commissioner of Police, Mr. Abakiari, I have expressed the view this afternoon that if he does not surrender himself, since he claims that he's innocent of the allegations, the United States government will have to submit a request to the government of Nigeria to extradite him to the United States, because there is a treaty between Nigeria and the United States which covers the offenses alleged. And once that request is received, the Attorney General will have to file extradition proceedings in the Federal High Court. So we have to show, we have to demonstrate that we are part of the civilized community, committee of states. And that is the only way we can be respected.
All right.
And unless we respect the rights of our people and the human rights of people in our country, we are going to be embarrassed continuously. And that is what has just happened in the United States, where a senator has moved a motion that certain weapons, aircraft should not be sold to Nigeria because of gross human rights violations.
So, Mr. Falana, we're due to close now. In the next 20 seconds, we are totally out of time. But I wanted to just point out that the federal government has not come out to say how they brought Nnamdi Kanu into the country. And the government of Kenya has come out to say, no, the case is not exactly the way it's been reported about how it was taken from Kenya. But just in 15 seconds, where do we go from here? How do we resolve this matter? A political conversation? Just 15 seconds.
No. What we're told by the government was that there was an international collaboration among security agencies. And as far as the law is concerned, because Interpol was mentioned, the power of Interpol does not go beyond issuing a red notice and asking security agencies in any country to arrest a person wanted by another country or in his own country. And once that is done, Interpol does not get involved in the repatriation because the arrest is pending extradition, pending legal surrender. It's very embarrassing for Kenya, and that is why Kenya cannot say, oh, this gentleman was arrested in our country. But the British Guardian newspaper had already traced Nnamdi Kanu's passport, British passport, to the territory of Kenya, and that has not been denied. And that goes a long way to confirm that he was actually abducted in Kenya. The government of Nigeria cannot admit that we abducted him. Hence, they say he was intercepted. The government of Kenya cannot admit that he was abducted in their territory.
All right.
Because the human rights community in that country will take it up with the government. Nobody is saying that a criminal suspect should not be brought back to the country. More so, somebody who has done bail. But he has to be brought to the country, back to the country, under the rule of law.
Mr. Femi Falana, Senior Advocate of Nigeria, it's a pleasure having you speak on these national issues. Thank you indeed for your time. Appreciate it. Well, that's our show for today, everyone. Many thanks for watching. I'm Sean Kimbalwe. Bye-bye.